We have a number of senators anxious to ask questions, and we'll begin with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and thank you to the witness. We're honored to have you testify before our committee of the Senate here today. I would like to ask you, firstly, in comparing and being able to compare the Canadian system to other systems of voting in the world, is there any other system that is comparable to the Canadian system in that, well, witness, I'm the oldest person here in this committee. I've been on Parliament Hill for 40 years. And prior to 2007, the very time when the report came in Britain that you referenced, there was a report from the House of Commons that suggested changes in the Elections Act, and for the first time Canadians had to, because it was adopted by the government in 2007, for the first time Canadians had to show ID. Prior to that, there was no requirement. If you were on the voters list, you just said, this is me, this is the address, yes, you got me on, so therefore I'll go and vote. If I'm not there, I just take an oath that I belong to this polling division, and that was it. And the changes came in 2007 requiring documentation, identification. And we've had several court cases since then based on those requirements. And I imagine we'll have many more court proceedings as a result of this most recent change. But, Professor, the main point about the Canadian system, and I don't know if this is comparable to any other system in the world, is that we have in the Canadian Charter of Rights and Freedoms, Section 3, which says every citizen has a right to vote in any federal or provincial election. All you need be is a citizen and in a particular polling division in a provincial or federal election. If you add anything to that, it's a violation of the Charter, and that's what every court case has said. So then it boils down to whether or not it's demonstrably justified in a free and democratic society as we define Canada to be in the Charter. So then the argument boils down to, do the salutary effects of the legislation outweigh the deleterious effects of the legislation? And it is upon that judgment that court decisions rest regarding requirements of identification. Is there any other system that you know of, or that we can logically and reasonably compare the Canadian system to, in that in Canada you have this constitutional right, all you have to do is be a citizen and be living in a particular area, and then the final judgment being made on salutary and deleterious effects. Is there any other jurisdiction that you can think of that operates that way?
Well, you're bringing up the question of the Charter of Rights and Freedoms and of court decisions on this. And this is itself an extremely complicated area. Yeah. I was a member of the UK Commission on a Bill of Rights, and so I'm very much aware of the controversies about court decisions on these things. Now look, let's be clear. From the UN Charter and Convention, that universal suffrage in fair and secret elections is a basic rule. And so we certainly do start off with the view that everyone must have a vote. There are a few exceptions. I mean, there are questions about prisoner voting, there are questions about, say, the British royal family or members of our House of Lords. If you were the equivalent in Britain, you wouldn't have the right to vote, but you would be an exception. But in general terms, everybody has the right to vote. I don't believe that necessarily implies that you have to prove that everybody who presents themselves at a polling station can't vote, or else their ballot must be accepted. I mean, after all, we don't know if people are citizens. We have a very mobile population. And so I would have thought that it would be unreasonable to so tilt the balance that the assumption is that everyone who presents themselves can vote unless it's otherwise. And I would be surprised if future courts were acting that way. What we really need is a matter of common sense, and in order to safeguard the integrity and reputation of elections is to introduce reasonable measures that assure us that those who cast their ballots are whom they say they are and are entitled to vote, and those who are not entitled to vote don't cast their ballots. I mean, that's what a good democracy is. And so what we should all aim for together is a system that is accurate and rigorous to that extent, but is also inclusive. And I think the arguments in principle that I think have been slightly unhealthy in Canada recently have been to suggest that you go one way or the other. We surely must do both.
Is there extra time? The doctor has indicated that's the case, and we'll move to Senator Frum.
Thank you. Welcome, Dr. Duschinsky. It's really nice to see you by video conference at least, and thank you for joining us today. You submitted in your statement to us, you made this point about, well, you've just referred to the unhealthy debate we're having here in Canada, and I agree with you, it is unhealthy, because one of the arguments that is made by opponents of this bill is that there hasn't been sufficient evidence of fraud, and therefore one shouldn't try and make the rules more robust in absence of evidence of fraud. And you have said it's not enough to argue procedures haven't been abused in practice. You must ensure procedures are robust enough so they're not open to abuse. And I would just like to add, as part of that question, a paragraph from the compliance report, the Neufeld compliance report from the last election, where he says that 12 million Canadians cast ballots on May 2nd, 2011, and the audit indicates that the application of specific legal safeguards in place to ensure each elector is actually eligible to vote were seriously deficient in more than 165,000 cases due to systemic errors made by election officials. So, I guess that's a two-part question. How do you react to 165,000 errors? But even in absence of those errors, this argument that we just don't have fraud in Canada. How do you react to that?
I have a lot of sympathy with Harry Neufeld's work on this. He does distinguish between actual proven fraud and administrative error. In Britain, there has been proven fraud, but it should be noted that it was only proven after many years of denial, that for many years the government, the electoral authorities were in denial, and then some spectacular cases came up afterwards, and especially one in Birmingham in England, but then it turned out that there had been all sorts of local evidence that had been systematically ignored. So if it turns out that the difficulty is merely theoretical in Canada, then I think that is an important point. And so I certainly wouldn't ignore what such a senior election administrator as Mr. Neufeld has said. On the other hand, we have found in Britain that if a system is open to abuse, then sooner or later, and usually sooner, that abuse will occur. And I think that if you look at what happened in Britain, you'll see that as soon as certain cases started coming up, then the police and judges did give the view that the system had been open to fraud all along. For example, the Assistant Commissioner of the Metropolitan Police, the famous Scotland Yard, said that it was their view of their Special Prosecutions Unit that widespread use of postal votes had opened up a whole new area to be exploited by the fraudster, and the opportunity has been taken. A senior judge said that the system invites fraud. Another judge said that the system was wide open to fraud. And the chair of the Committee on Standards in Public Life said that electoral fraud is a real and potent threat to our democracy. So although I'd accept Mr. Neufeld's point, I do think that you've got to err on the side of caution as far as the robustness of the election process is concerned, provided that you also have special measures to ensure that disadvantaged groups can be registered and don't suffer. So I would be tough on the one hand on the rules, but also active in special measures to ensure that those rules don't bear on disadvantaged groups.
Chair, may I add something to that? I'm intrigued by this concept of electoral commissions being in denial and not pursuing investigations. One thing we've learned in these hearings so far is that, for example, in our vouching system, there is no follow-up. Once someone has been vouched for and the voucher either properly or improperly, in a third of the cases it was improperly, vouches, Elections Canada then does nothing with those ballots afterwards to audit them or ensure that there was appropriate compliance. So that to me is being in denial, is showing no interest in investigating, or auditing an important process. So I'm just wondering about that idea about elections commissions, not just, and again, I agree with you, we should not get personal, it's not, but just the inherent nature of an elections commission to be in denial, which you said you see in your own country.
Well, I do think it's important that we don't make groundless imputations against senior electoral administrators. I think we draw back the opportunity of really a sensible discussion if we go in that direction. And as I say, I have the greatest respect over many years for your election administrators. I think, however, there are some systematic questions that open. That an election administration involves, on the one hand, a lot of very, very detailed work that is rather boring, frankly, but has to be done accurately. It's rather like hospital screening, that there are a lot of things that have to be done. The kind of administrative setup that is efficient for that is often not the same as the kind of setup that is investigative. In other words, for investigation you require forensic skills, a certain amount of suspicion, and the kind of organization that is there to sniff out what's going wrong is often not the kind of organization that is just running tens of millions of ballots. And there are the different functions. And the trouble is that during an election period, the electoral administrators are so busy doing their jobs that they don't have time and they don't employ the kinds of person who would be investigators. And so you really need different teams to do the different jobs. And that's from the nature of the jobs themselves and not from any lack of merit of the people and organizations involved.
as you know, that is in our bill, and I'll let some of my colleagues follow up on that, because indeed you've just described one of the important measures of Bill C-23. But I'll hand it over to someone else to
Senator
continue.
Moore.